Well, good afternoon. I hope everyone had a nice lunch break. It's so beautiful outside. The sun, gosh, I mean, we're not used to this beautiful weather back home, although in Hawaii we are. So it depends. So this afternoon I decided not to use PowerPoint because sometimes PowerPoint kind of drives the discussion, and I'm thinking I'm going to be flipping back and forth, first of all, to help keep you awake. But I also want to do my best to respond to your questions and comments. So I have high expectations that you will be actively involved in this afternoon's discussion. And I also mentioned this morning, anybody remember this morning, the coffee or anything? But the fact that we're going to be talking about discipline, but I want to talk initially about behavior and the proactive expectations. If you turn to page 1, and by the way, throughout the outline, I have put a few inserts from the Idaho Special Ed Manual in there, where Idaho is a bit more specific than federal law, and in some cases elaborates where federal law does not. I did want to just start out by looking at evaluation requirements under the IDEA. And evaluation requirements regarding, first of all, the evaluation requirements state a couple things. One, the proposed or suspected category of disability does not necessarily drive the scope of the evaluation. And as you hopefully know, the IDEA says that the evaluation must be sufficiently comprehensive to identify all of the child's special ed and related service needs, whether or not commonly linked to the child's either suspected disability, or if it's a reevaluation, the disability area or areas where the child has already been deemed eligible. What does that mean?
Well, you don't just focus on behavior if that's your only thing.
You don't just focus on behavior.
You have to assess all areas that there's a suspected disability.
And by the way, a child need not be separately identified as being eligible, for example, as emotionally disabled before behavior is assessed and addressed in the IEP. So it could be that a child with a learning disability in the area of reading or suspected learning disability, based on input from parents, input from teachers and other service providers, behavior has become an issue which we think may be impeding the child's learning. So we may have to assess the child's behavior even though the main area of focus is a reading disability. So the label or category is not the end-all in describing the scope of the behavior. Now, I know several people in the audience are behavioral specialists. I am not. So I'm going to also rely on your expertise to supplement this. The term FBA, Functional Behavioral Assessment, without looking at the outline. In the Idaho Manual and under the IDEA, where is that term used?
Manifest determination.
In the discipline section, and only in the discipline section. That term is not used in the IEP section. Only in discipline. However, the U.S. Department of Education has helped confuse this. Because you will see on the bottom of page 1, you have permission to look at your materials now. Under paragraph 2, as I mentioned, the IDEA doesn't use the term FBA except in the area of discipline. However, in a guidance document, and it's a Q&A document that's going to be referenced here throughout. It was 2009, where the feds put out a series of Q&As on various topics, one being behavior and discipline. can I just carefully say, when the new administration took office, the IDEA website disappeared. There was some discussion that it became that there were internal technical problems with it. There was quite a feedback from the field regarding its disappearance. It's been resurrected. It's been resurrected. So these documents are available on the website, and I think you just go to idea.gov. And there's a part C and a part B on the front on the website. You hit part B, then it gives a list of topics where the Q&A documents and other technical assistance. So it's been resurrected again. These documents are available not only through the Individuals with Disabilities Education Law Report, which is a private subscription service, but for free of charge on this idea.gov website. So it's up and running again. They fixed it with some impetus from the field. So I happen to have a full printed copy here if people are interested, but I'm just going to be citing, and this is in 2009 that this came out, where if you look at the bottom of page 2, they talk about, meaning the U.S. Department of Education, uses the term FBA outside the confines of discipline, but to talk about an FBA is generally understood to be an individualized evaluation of the child that may then lead to the development of a behavior intervention plan. That term, BIP, is used only in discipline. And I'm going to tell you how I use the terms. Page 2. I made indirect reference to this today when we were talking about the Timothy O case, where the school psychologist did an observation of the child being assessed and said, the kid doesn't look autistic. You don't look ADHD. You look emotionally disturbed. We remember that case? Where in this letter to Gallo, the U.S. Department of Education first said that consent has to be obtained before a behavioral observation is done as part of, they said, as part of an FBA, but I'm going to extend that as part of a behavioral evaluation. In other words, if a structured observation is part of the evaluation, we are collecting data to address not only the threshold question of eligibility, but remember, an evaluation is twofold. Collecting data to determine whether the child qualifies, and if so, what the child's needs are that need to be addressed. In the letter to Christiansen, I have never seen this used in this context, but the Fed said, if an FBA is used to address a school-wide evaluation process, look at the first paragraph under C. So if we're looking at positive behavioral supports and we want to evaluate the system and the entire school, that's not considered an evaluation. I've never heard the term FBA to be used kind of as a systemic tool to evaluate a school's approach to behavior. I learn every day. Have you? I was in a state, we were talking about this, and then we got to talk about PBIS, and someone says, well, we have PBS in our school. And I said, I have PBS at home. PBIS, again, kind of a school-wide approach to what? positive behavior interventions, kind of a school-wide, it's not part of a student's IEP, but it's a school-wide systems approach to promoting positive behavior within the school. And I've even seen some cases that talk about, well, the PBIS was in the student's IEP. I have not seen the term used to describe an individual student's program as PBIS. Have you?
So we do use the term positive behavior support,
Positive behavior supports is in the law.
but not the intervention piece. And I could see a screening, an assessment at a school-wide level being a screening for moving kids from Tier 1 supports to Tier 2. So in that context, you could have a school-wide evaluation or screening process that probably would require that parent permission component, correct?
Am I going to have to repeat all this for this afternoon? I'm sorry? So what I'm going to do is ask for an accommodation. Instead of me repeating everything, I'm going to ask people to even maybe stand up, use your playground or classroom voice, and let me know if it picks up, because I don't want to misconstrue or misstate what your comment is.
You're on, Renee.
So crank it up.
This group knows I don't crank up really loud, but I'll try. All right, so you had a question about PBIS in conjunction with individuals, and in the IEP process, we are required to look at positive behavior supports, but that's lowercase p, lowercase b, lowercase s, as in we're looking at positive interventions and supports for students. And that's different than the capital PBIS, which is a systems approach. That doesn't mean that we don't want our students to be engaged and connected to existing PBIS supports within the school, because we know that's best practice. And then second, you were asking about a school-wide behavioral assessment that might be delivered to schools. And in the context of the PBIS systems, there are screening procedures that can be used as whole schools to qualify a child or to identify those individuals that might move to a Tier 2 intervention.
But qualify them not for special education.
Correct. Just for a different level of intensity of support.
And so, terminology sometimes is very important. So when you say a child has been referred, that doesn't necessarily mean a referral for special education. When you say a child qualifies, we have to put it in the context, and the context that I thought I heard was a multiple tiered support system in gen ed. Not qualifies for special ed at this point. And I wanted to turn to, and I'm keeping to Roman numeral 10. I believe it's on the bottom page 23, top page 24. You with me? So if you look at paragraphs 10A and 10B, we're talking now about behavior assessments and behavior intervention plans under the IDEA's disciplinary provisions. If you look at the notes, the terms FBA and BIP are defined in the Idaho Special Ed Manual in the glossary, but they're utilized as the IDEA does. Those terms are only utilized in the discipline section of the manual. So I'll just tell you where art's coming from. Outside of discipline, I talk about behavioral assessments and behavioral components of an IEP. Even the term behavior intervention plan, I have seen in places people think it's another plan that spins around outside the IEP. It's not a separate plan. So I talk about a behavioral component of the IEP. I talk about a behavioral assessment and the level of assessment and the scope and the formality of that assessment is going to be up to what? The team. So if we jump back to page 1, I told you we're going to keep us turning. Under 2A1, the law says that when we evaluate behavior, we're going to use, quote, technically sound instruments. What's a technically sound instrument that addresses, that would be utilized to evaluate a child's behavior? Is it a test? Is it true, false? In fact, we don't test children to get into special education. It's not pass fail. And I'm not sure if the kid passes or fails to get into this. But in other words, technically sound instrument. Help me, you're the professionals who put these words into practice. What does that mean?
I read it as an assessment tool that has been validated, that has the technical research has been done to show that it measures what it says to measure, and it's a reliable tool used for that purpose.
Give me some examples.
Like a behavior rating scale, such as the BASC.
The BASC, the Connors, the old days, the Achenbach. I mean, in other words, but what is it? It's still a collection and analysis of observational behavior from multiple sources, is it not? Done thoughtfully and cohesively by the team. I mean, it's not responses of the student to test questions. So a technically sound instrument. And a technically sound instrument in a given case may be very well and look like a textbook definition of a functional behavioral assessment in a given case. But that term itself is used only in discipline, and it's not even defined under the IDEA, although the manual defines it in the Idaho manual defines it in the glossary, but utilizes that term only in discipline. You with me so far? I also, and I'm not going to go through each of these pages, and I'm going to depend on you to lead me. One of the things we have to be careful when we read court cases is to make sure the court case we read is interpreting IDEA. Example, a judge in a state west of here, that kind of reduces possibilities, found that the IEP for a student with autism was legally inappropriate because the school had not conducted a functional behavioral assessment that led to the development of a behavior intervention plan. And they cited a case from the Second Circuit Court of Appeals that held just that. And that case is cited on page 3, paragraph F. But when you look real closely, that is based on New York state law that requires that if a student is autistic, they will have a functional behavioral assessment that will lead to the development of a behavioral intervention plan as part of the IEP. You can't impose New York state law requirements in Idaho or other states. So I gave that judge some feedback after their decision was rendered. They reissued the opinion, not at my urging. But I wanted and I was not involved directly in the case, I was a consultant, but I wanted them to understand that they were using as precedent a case that was based on the uniqueness of state law, not the IDEA. So, couple things. Behavior, as part of the assessment is not dependent on the label or category. It's a team decision based on what we know about the child, review of existing information, input from the parents, service providers. And if it's going to be more than a review of existing information, including a structured observation of the child to collect data, that will be deemed an evaluation invoking the procedural safeguards of prior written notice and consent from the parent. If it's just a review of existing information, we don't need to get parent to consent to review existing information. I also wanted just to point out, well, this is another New York case, but on the top of page 4, the school psychologist said, we don't need to do anything in terms of an evaluation because the evaluation that I observed for this child who's autistic is basically not unusual for a child with autism. The court said, you missed the point. That's almost a quote. The court says an evaluation is to acquire information for that child, not whether the child's behavior in this case is typical for a child with autism. So now we're using evaluation here, and let's hold off on discipline till a little bit later this afternoon. We're using it now proactively, which would then give the team assessment information, which would, under paragraph 3A, based on that evaluation information, the team's going to have to answer the question, does a child's behavior impede their learning or the learning of other students? If so, the team needs to consider this is where the positive behavioral intervention supports and strategies would have to be considered. And potentially, if the team feels that they are required, that goes into what I call the behavioral component of the IEP. And I've seen often people call it a behavior intervention plan. And I'm not going to say that's illegal or wrong, but that's not quite how the law uses those terms. In fact, we have a couple court cases where the court overturned the lower court's decision because they ordered a behavior intervention plan, and the court said there is no requirement for a behavior intervention plan outside of discipline. In fact, one court said the plan doesn't even need to be in writing. The Eighth Circuit. Do we know it when we hear it? So I think we're talking about, and this is the confusing part, is sometimes the terminology and the context we use it. It's my sense that in Idaho, FBAs and BIPs are used more broadly than in discipline as kind of everyday use of those terms. And then what is an FBA outside of discipline?
Drives the behavior plan.
No, I mean, there's no definition, because the definition in Idaho in the manual is based on the use of the term in discipline. Now, there's like a school psychology textbook definition, and I think there's a common professional understanding. But even in discipline, when the regulations were last revised comprehensively, I submitted 57 pages of single-spaced comments. Get a life, Art. Doesn't that sound like fun? I have a copy of every state's regulations, so on a Friday night, ask my wife over a glass of wine, pick a state. And I just read excerpts of the regulations. Nah, I'm only kidding. I would need a referral form if I did that. But go back to paragraph 10, 10B. So everybody knows what the Federal Register is, which is kind of the newspaper for federal regulations that contains the regulations and all the public comments and the Fed's response to public comments. By the way, when my eyes started having some difficulty, I go in get my checkup, and my eye doctor asks, "What do you do?" And I, of course, carry my regulations with me at all times. So I showed him. He says, "No wonder you're having problems." This is like in .2 font, you know. But the comments to the regulation said one commentor, that was me, I was so excited. One commentor asked for a definition of the term FBA. If you look at paragraph 10B, the regulations say we are not going to define FBA even in the context of discipline, because that's best left to the local education agency, the school district, the charter school, the parents and relevant members of the team. So even the feds in discipline have not adopted the definition of an FBA from the school psychology textbook, but have left the comprehensiveness to the team, the formality to the team. However, in Idaho, we do have a definition of FBA in the context of discipline. And it much more closely follows what I understand to be in the school psychology textbook definition. School psychologist, I know we had a couple here this morning. Would that be fair that the term under paragraph B in Idaho kind of follows what school psychologists often would see as a FBA? I see affirmation. Let me go back to page 4. Positive behavioral interventions and supports and strategies. You know, the feds have said in the past that the IDEA does not per se prohibit the use of restraint and seclusion. And in 2012, they issued a guidance document with 15 principles about the use of restraint and seclusion. And by the way, the data collected by the Office for Civil Rights shows that students with disabilities receive the, quote, interventions of restraint and seclusion at an inordinately higher rate than the general school population. It's my understanding that there is no law specifically addressing the use of restraint and seclusion in Idaho, either in IDAPA or the manual. But I want to go back to the use of positive behavioral interventions. And the 15 principles underscore that restraint and seclusion is never to be used for punitive purposes, only as a last resort when there's an imminent issue of safety for the student himself or herself or others. Utilized by trained people. I'm real concerned when I see restraint and seclusion be the behavioral plan. That is not going to make me comfortable. On the other hand, there are cases over the years, and if I put every case in here, you wouldn't be able to walk home. There have been situations where the parent says, "Read my lips, IEP team, you will never touch my child." You can't abide by that. Why? Because there are what's called errors of commission and errors of omission. So this child's about to hurt herself, and I say, "Stop." The mother told me I can't touch her. I mean, I need to be able to use the necessary and reasonable, even physical contact if necessary, to prevent her from hurting herself or others. The biggest legal liability issue I've seen over the years on the use of restraint and seclusion has been lack of training of staff who have been asked to carry it out. So if there's restraint and seclusion in the IEP, it should not be the first level of intervention. But I think it's going to be incumbent that, remember, the IDA says that all individuals must be informed of their specific responsibilities in implementing the IEP. So for behavioral interventions, that means the teachers, paraeducators. Oftentimes the calls I get are behavioral issues outside the structure of a classroom while kids are changing classes in the hallway, lunchroom, bus, playground. So rhetorically, if the child has a behavioral component with behavioral interventions, what steps has the school taken to inform and then educate those adults that the school is putting in a supervisory role over that student? OCR, the Office for Civil Rights, issued a paper in 2016 that's referenced on the bottom of page 4, top of page 5, that said in some cases the use of restraint and seclusion, although it's not per se prohibited by 504, could amount to discrimination. But I want you to look at the first full paragraph on page 5, where this covers actions not only by school officials, employees, but if you're contracted by the school or have some other arrangement with the district, such as a school resource officer. Whether they work for the district directly or not, are covered by the limitations on the use of restraint and seclusion. And what I'm hearing, and by the way, people don't call me to say, you know, everything's going great today, Art. The sun is shining and everyone's happy. I don't get those. I would like to get more of those calls. But when I'm getting calls from parents who are very upset, some school staff who are very upset that the school building administrator or others has called the police to come get this child and handcuff the child and take the child away because they feel that they are too limited in their ability to address the issue. Be careful, be careful, be careful. And this is suggesting that the limitations and protections of 504 also apply to actions by individuals such as school resource officers. Yes?
So I get that special ed connections. I get that special ed connections, try to release my inner lawyer, but I'm always wrong. So on the restraint and seclusion, it seems like it's not consistent. Some people say put it on the IEP. Some people say leave it off and just refer to your district policy. What do you see most places doing? Putting it on the IEP or?
I will tell you Art's random thought, since I can't give you advice. That if restraint or seclusion is a likely intervention, not the first intervention, but a likely intervention, I would want to be put in as part of a comprehensive behavioral support system. Because I want people to thoughtfully use it as a last resort if other interventions have not been successful. And what's really, as I said, one of the most common issues that I see is the lack of training when implementing it. And so I'm the paraprofessional or teacher, and I'm acting off the seat of my pants without any training on how to implement that for that child. And I will say my own style has been kind of touchy-feely, and I think some schools have gone overboard because of their concern of harassment and so forth, and said, schools, staff members, I'm sorry to say this, don't ever touch a student. We just can't risk the thought of a harassment claim and so forth. I find that unfortunate and an overstatement. I like to believe, I'm kind of limited here, but if a student is doing good, I like to say, keep up that work. That's great work. Now, if I'm one-on-one with a student, I think I have to be very careful and turn up my sensitivity meter. But if restraint or seclusion is going to be a likely intervention or a very probable intervention, I would want to see it described as part of a comprehensive behavioral support component of the IEP, kind of the bottom line after everything else fails, but what to do so people are put on notice of how to do it. Also, going back to my high school days as a teacher, I had a child, a young man who had some behavioral outburst issues. The counselor, and some of you may have heard this story, but that's who I am telling my stories. I was told by the counselor, Art, don't get in his space. He had been sexually assaulted by an adult male family member. I didn't need to know all the details, but if an adult male got in his space or attempted physical contact, he was likely to react. I needed to know that. I didn't need to know that Uncle Harry up the hill had sexually assaulted, but I needed to know that. So I do think at times restraint and seclusion could be a component, kind of the last level of intervention when other levels of less intrusive interventions are not effective. Because it has to be potentially individualized for that child and not just a one-size-fits-all approach. So I heard you say, or can we just rely on district policy? And by the way, not all children with disabilities present, the majority of children with disabilities don't present behavioral challenges. So I'm not saying this should be part of every child's IEP. And there's a lot of kids who are not disabled that are a handful. So, you know, misbehavior and disability are not synonyms. But when it's a likely intervention, we have to talk about how it would be implemented for that child based on their individual needs. Then we need to alert the people who we put in a supervisory capacity. So this kid is on an IEP. She's never presented a behavioral problem, but she's having a real bad hair day today. That doesn't prohibit me from following district policy and the utilization of restraint and seclusion if I need to. Does that help? And I would underscore, if it's part of, hopefully it's part of your district policy, but in the IEP, this is not to be used as punishment or in any way as a punitive measure for this child. It is only to be used under the following circumstances. Less intrusive interventions have proven to be unsuccessful. There's an imminent threat to the safety of the student or others. And so putting in some conditions on its utilization. I will say Idaho is somewhat unique in that respect of not having a restraint and seclusion law. I'm assuming a number, if not the majority of districts have some level of policies regarding restraint and seclusion. Is that a fair statement? I see some people shrugging their shoulders, some people saying yes. I think, again, I want to actually acknowledge and applaud the U.S. Department of Education, because I criticize them enough. On page 5, there is a memo that went out August 1st last year. It's 16 pages addressing behavior and discipline. I think it is a wonderful tool to use for one of your staff meetings. By the way, a wonderful tool to use with a staff meeting of building administrators, principals, vice principals, otherwise known as the principals of vice in the school. Because this really doesn't break new law, but it kind of capsulizes in an understandable fashion what the law is regarding behavior and discipline. And it talks about, among other things, being careful to before behavioral concerns is utilized in making a placement decision unless behavior has been attempted to be proactively addressed in the IEP in the behavioral component. How can we justify moving a child to a more restrictive environment due to behavior if we have not thoughtfully and cohesively implemented positive behavioral interventions and attempted that? And with any behavioral intervention, help me, you're the experts here, we have to keep data on their use and effectiveness. And I'm going to give you some examples. But this also talks at the very bottom, the use of certain exclusionary measures, that's the term they use, when used over a period of time, really become not behavioral interventions, but disciplinary suspensions or disciplinary actions. So what we call it is not necessarily what it's going to be if challenged. And I'm going to give you some examples of these, but a pattern of office referrals, extended time excluded from instruction such as time out, restricting privileges, sending kids home on administrative leave, or we're going to give you a day off. Sending the child home early from school, sending a kid home with the condition that they can't return unless there's a risk assessment done regarding their safety. Let me give you some court cases of examples of some of these exclusionary measures where the court said the utilization of these measures really became disciplinary suspensions. A case from New Hampshire. I live in Vermont. And again, I live in the state where we're fat on the top and skinny on the bottom. New Hampshire's fat on the bottom, skinny on top. Live free or die, or eat Ben and Jerry's. So you have a choice here. Here's a kid who is LD and ADHD on an IEP. His parents took him to see a child psychiatrist. He was put on medication, and the school saw a dramatic improvement in his behavior. Mom then got on the internet and saw the potential adverse effects of that medication. For TV, I watch news and sports, basically. Almost every ad in the news, on a news program, is for what? Meds. And they talk real fast. And the potential side effects for this medication are uncontrollable diarrhea, loss of limb, and death. Yeah. And if a certain condition lasts for more than 4 hours, please seek medical assistance. I mean, in other words, they, in the real fast, they talk about all there's side effects potentially with every medication. And the parent read online about the potential side effects of the medication that her child was taking. It was Ritalin. And, stunted growth, etc. So she unilaterally made the decision to stop administering the medication. The school saw the impact of that, where they saw the behavior regressing. And as we know now, the law is very clear. I thought it was always clear, but now it's in the statute and the regulations that schools cannot condition education or attendance at school or receipt of services on the parent's administration of medication. It may impact where the education is provided, the least restricted, and so forth, but that's not our decision to make. But in this case, the child had a behavioral intervention plan that called for easement days. That was one of the levels, I believe a level 4 intervention. By the way, the term easement days was interesting. What happened there was that easement days was used to describe a situation if in-school interventions, if a child was disruptive and having a bad day and in-school interventions were not effective, mom and dad were called and come pick their child up. And the parent agreed to that as part of the IEP. Then the first call came. Then the second call came. And the calls kept coming. Parents then started, and this isn't the only grounds, but the parents challenged the IEP after it was used for the 20th time. Got into court. The school said, well, these are behavioral interventions. Who here was a former building administrator? Disciplinarian? Can you define for me what a disciplinary suspension is in a school context?
Removed from the general ed population.
Removing the student from the
General ed curriculum, access to general ed curriculum or their regular services.
Would you kind of accept this more formal definition? A suspension is a temporary cessation of services due to students' behavior which violates the student conduct code.
Sounds good.
So this kid was sent home for being disruptive to school and other behaviors. And what services did you provide this student, school? To the school staff member, what services did you provide the student when he was sent home? Can you speak up and say that again for the court?
0
Or sometimes I get homework.
homework packets.
The court said those were de facto days of suspension. The school said no, they were behavioral interventions. However, the data showed as the year went on, the little bugger figured out if he misbehaved, he got to go home and play video games. So although the school team initially thought this was kind of a proactive, sensible intervention for this child to get him out of the environment before it blew up any further, it was really having the adverse impact that they had hoped for. And the court said they were inappropriate in the child's IEP. And by the way, this was the case, this was in the early days where the school said, well, parent, something's got to give here, and you've got to place your kid back on medication. We all know now that that's a no-no. How about the second case from Pennsylvania? Big Beaver Falls as opposed to Little Beaver Falls. And here was a kid in high school. She would misbehave, and she was told, okay, young lady, your choice, detention or do you want to go home? A pattern started developing. The parents challenged it. The school says, we're not suspending her, she's choosing to go home. The court said, wrong answer. Again, those were de facto days of suspension. And a case that did not get to court, but that got to art. One of people who was in my previous workshops called me and said, oh, I'm so glad I caught you. I have a child. She's on an IEP. She's been in timeout for 4 days. And I said, timeout. The school had a timeout space. This child had been sitting there for 4 days because she was disruptive to the class. She was more than rude to her teacher. And until she sat there and wrote a letter of apology to her classmates and the teacher, she was going to stay there. What services was she given? Well, she was given her homework. I said, if you ask me, if push comes to shove, it's going to be seen as an in-school suspension. What services was she getting under her IEP? I got the same response. that's going to be deemed as, and she started arguing with me. She said, no, it's a timeout. And I said, I'm sorry, you called me. I'm giving you my best thought. I think if challenged, they're going to look at what it is, not what you call it. And she started arguing again. I go, you have a great day. So be careful of what some people may see as a behavioral intervention could morph into a disciplinary removal.
So I get the question a lot about if the student does receive their special education services while they are in that situation, does it count towards the 10 days?
On bottom of page 6, paragraph 4A. 4B. And this is in the comments to the regulation. That an in-school suspension does not count if 3 criteria are met. 1, that child is sent to the, quote, in-school suspension room for the same behavior that would be applied to any student in the classroom, whether they're disabled or not, so we don't have a different standard. 2, the child still is given the opportunity to participate in the general curriculum, So let's assume it's a speech-only child, or are they still able to get instruction, albeit in a different manner, in language arts and science and math? Opportunity to participate, they may still count the dots in the tile like they would in the classroom. And third, are they still getting their IEP services? So your question really just addressed the last of the 3 components. All 3 questions have to be answered in the affirmative before it is not counted.
Art, can you speak to the participation of non-disabled peers?
Participation with non-disabled peers. And I'll quote her, Jolita Reynolds, who is former state director in Tennessee and then was the person who wrote the regulations. She worked for OSEP. And she's a dear friend of mine. And unfortunately, she passed of cancer. And when she left the department, a lot of history walked out the door with her. And I would call her, and she says, I can't give you a formal opinion. So, Jolita, I'm just quoting you informally up there. I know she's not down there. But I asked her about this. And I said, here's how I'm interpreting. She first said, how are you interpreting it? I like when people call me and say, what do you think I should do? And I said, well, what do you think you need to do? And let them think about it. By the way, Melanie Reese is brilliant on that. I said, well, I see this, that if this child is in a gen ed class and is being removed and being placed in, quote, the in-school suspension room, I know in my kids' school at the time they called it the planning room, or the student assistance room, or they didn't call it the in-school suspension room. But if that child is removed for behavior that would result in any child being removed, who's in that room in any given day is dependent on who's having a bad hair day. Hopefully there's nobody there. It may be only kids who are non-disabled. It may be only kids who are disabled. It may be a mix. And she said, well, that's it. It really would be an extension of the classroom. So that first point was key. Is that kid sent there for behavior that would result in any kid in this classroom being sent there? That was kind of the key thing. I wish they had said that, because it makes more sense. Because if they're in school suspension, there may be nobody else there. Right? And by the way, if the kid is getting the services that are called for here, don't call it in-school suspension, because if you did accept my definition of suspension, temporary cessation of services, I call it alternative in-school instruction. Don't call it that. if you're not providing it. But if you tell me as a parent, my kid's been placed in in-school suspension, I think a lot of parents are going to perceive that to be kind of the holding tank, where their kid is just doing time in the room. If there's a level of instruction being provided and that kid's still getting their IEP services, come up with a different name. Because sometimes the terminology we use and how it's communicated really impacts the whole dynamics of that conversation.
So the kind of phone calls I get are, okay, so we have a kiddo who's in this, the lounge, away from the general ed curriculum. They are going to receive their IEP services, but they really are not with other students except for at lunch. Does that count for being with non-disabled peers for part of the day? And so they're really trying to figure out how much participation equals participation with non-disabled peers.
No, give me that example again for lunch. The kid's in?
Yeah, the kid is in separated from the general ed curriculum.
In a self-contained?
Self-contained.
Whoa. Just a clarification. Kids in a self-contained class, they still are obligated to focus on the general ed curriculum.
They're-
So the general ed curriculum is not dependent on the site where it's,
That makes
okay.
sense. So they're able to access the curriculum, they're not part of the.
But they're in a self-contained
Right.
program.
They're getting their IEP services, but they're not being able to interact with any of their peers, except for, do we have to count it as suspension if they get to have lunch with them? Or do we have to count it as a suspension if they can go to, 5 minutes of recess, or?
But during the regular IEP day, they don't have interaction with non-disabled peers.
That is what the question is, but at what point does that become the marker of counting toward suspension days? If they're not interacting with their non-disabled peers, what I'm hearing from you is that if a non-disabled peer could be in there with them.
If the same standard applies regarding behavior and who's going to be sent to this place, I think that's kind of the key to the analysis. And then services follow.
Even if it's individual.
I'm just trying to understand what you're saying, because I get the phone calls of how much does that have to be interaction with a non-disabled peer? What I'm hearing from you, that's not the criteria.
That's not the,
That's how it's.
did you have her corrected for me on
Yeah,
that?
I mean, that's what SMART starts, that Special Ed Connections tells us. That's the language, is continues to participate with non-disabled peers.
That's the language used right there, right?
So
In the,
the calls that I get are, how many seconds is that?
but it says, continues to appropriately participate in the general curriculum, continue to receive the IEP services, appropriately participate in the general curriculum. And it says, and continues to participate with non-disabled children to the extent they would in their current placement. And that last one, that last statement is what I used for my first analysis.
So it isn't how many seconds you're with a non-disabled peer, it's whether a non-disabled peer would have access to the same room.
Or would have the same restrictions placed on him or her for that same behavior.
Thank you. That's very-
And by the way, Jolita, thank you. I mean, she's the one who wrote this. And so I am quoting her. She asked me not to when she was with the department, when she was too ill and had to leave the department. I talked to her a lot, and she said, "It's okay now." And so I'm assuming it's okay now, Jolita. So that's how I'm viewing it. But if you look at this literally, it's hard to make sense out of.
It is.
So I'm giving you my best thoughts based on,
There's no court analysis on it, or there's no case analysis on it, though.
not that I'm aware of. I'm giving you my best thoughts based on, shall we say, the primary source. Excuse me.
And parents will report to us, just to kind of dovetail on.
I'm not sure everybody could hear on this side.
So parents would be, I'm with the Parent Center for Idaho, and parents would report to us, just dovetailing off of Melanie, their frustration over the IEP team's decision to educate for 3 hours a day. And that's based on behaviors. And so typically, the IEP team would make the decision, we'll educate for 3 hours a day, and that's how much a student.
So you're talking about the shortened school day?
3 hours.
Yeah, well, first of all, that's a little bit different than in-school suspension. Shortened school days. Are shortened school days permissible? I think the answer is yes. I think they're permissible primarily in situations where the child's medical condition is such that they cannot tolerate participation for a full school day at this point. But even behaviorally, most of the shortened school day cases that I have reviewed are from the Office for Civil Rights, where the building administrator makes the decision that this kid's participation is going to be shortened at this point. So first of all, one person makes a decision outside the IEP team process. That's suspect right there. I'm mildly comfortable with a shortened school day if, number one, the team is able to articulate why the child needs a shortened school day, not for staff respite, but why the child needs a shortened school day. I would want to see a goal to incrementally increase that child's participation to a full school day immediately, and what do we need to do incrementally toward meeting full participation? And if I heard you say, and I don't know if you meant it this way, the kid's coming for 3 hours. If every kid with a shortened school day gets 3 hours, my suspicions are rising regarding the individualization of that decision. And to me, that's a team decision, parent involvement. What makes that appropriate for the child? Why does the child need that? I think that's a key there. And then an immediate goal for full participation. So a shortened school day, in Art's opinion, should not be the placement.
So the case, I think, Jen, I think I know which case we're talking about. The case that I think that we're addressing actually has happened in several different areas, but you have a kiddo whose attention span and emotional ability to attend all day, his behavior's escalated after 2 hours, 3 hours, and by 3.5 to 4 hours, the data was showing that the kiddo just couldn't participate. And so the goal of, in one case, the goal was to bring the child more, but at that point, for a period of time, it was 3 hours a day, then 3 hours and 15 minutes, and then 3 hours and then 3.5.
But does it necessarily mean 3 hours and then removal? Or could it be 3 hours in the classroom setting and then supplemented by individualized instruction that promotes the return of the child?
And that wasn't the case in what I think Jen's talking about. But it was a team decision based upon data of the kid's ability to attend, not teacher respite or frustration with the student.
And there's not in fact, I did some research recently on that. Most of the cases that I found are from OCR. And most of the cases is when a building administrator, and by the way, my college roommate's a principal in New Jersey, not an easy job. I want to acknowledge that. But when the building administrator makes decisions outside the context of an IEP team that impacts the child's participation.
So Art, I do have a question for you. So would you, based upon what you said, that it would look better, or it would be better if it was a incremental reintroduction of the student into the general curriculum, since that didn't happen, would that be a non-compliance issue? Or because the team made a decision based upon the data of the child's ability to attend and to be productive and gain from the curriculum, is that compliant?
Well, let me just ask a question before I answer. So the data at this point, assessment shows that the child cannot tolerate a full day. Child can't attend. What is the school doing to address that child's needs, to allow them the ability for increased participation? I mean, if they're doing nothing, then I do think it's a compliance issue. Because it's really discrimination by not allowing and affording full participation. And if the team is not making a good faith effort to address the underlying reasons why the child can't participate, again, absent medical conditions where we hope the child will progress so they could participate. You're not in charge for medical treatment. But you may be responsible for home-based instruction to supplement the, for kids with chronic medical conditions. But my question, if they're doing nothing, I think it's about the child's ability to attend or participate in increased, incrementally at least. I think it is a compliance issue. Because a shortened school day should not be the placement for the child's IEP, period.
So Art, can I go back to the question before Jen?
No, because I can't remember, because I don't even remember that question.
I'm gonna summarize what I thought I understood. So you have a student who has a behavior that would put them in a pull-out to a separate educational setting, whether you were disabled or not. Your behavior requires you to receive instruction maybe in a pull-out classroom. So I get my instruction in this pull-out classroom.
And the IEP services.
And the IEP services, yes. And the next day I have the same behavior. And I am pulled out a second day. And the third day I have, at what point in time does it become a change in placement?
Well, first of all, I'm going to go back. Does behavior impede the child's learning or the learning of others? I think in your hypothetical, the answer is yes. So again, my question is, what did the team decide should be in the IEP for positive behavioral interventions and supports to address the behavior that's getting the child in this predicament? And it may address it. But we have to keep data. If it's unsuccessful, do we need to think about refining the IEP? I got in an argument a couple months ago with someone, and they said, well, you have to hold an annual IEP meeting. I said, at least annually. If the child is not making progress in any IEP goal, including behavior, we don't wait until the annual IEP necessarily to say, do we need to refine the IEP? She argued with me that they can't meet more than once a year. I said, you're missing a couple words, at least. So those would be questions that I would pose. Well, first of all, if the kid has a behavioral component, is it being consistently implemented? And oftentimes it is not, in which case we have another issue to talk about, and potentially a compliance issue. But I would not want to justify moving a child to a more restricted placement for behavior when the kid has a behavioral component, but it's not being consistently implemented.
Thank you.
You're welcome.
Good answer,
Oh. Thanks. A couple. And a couple cases, and then we're going to take a break and move to discipline. Page 7, paragraph 2, a case from Nevada called the Yates case. And this just illustrates, and there got to be, and I know some of the people involved in this case, and it got to be misperceptions of terminology. What did the court there say? Under the IDEA, a child, there's no provision in the IDEA, this, by the way, was not discipline. There's no provision in the IDEA that requires a behavior intervention plan, but interventions, supports, and strategies have to be addressed in the child's behavior. That kind of underscores what I talked about earlier, just about the distinction. Paragraph 3, a case from Missouri, where there was a child who was in a school with PBIS. So everybody in the school was subject to the positive behavioral intervention system of the school. But in addition, this child had a behavioral component in their IEP. So there were school-wide supports, but in addition, it was individualized. And this child's IEP behavioral component, in part, called for the use of a support room and a secure observation room to address dangerous behaviors. The support room was defined as a regular-sized class where the student could go take a break, refocus, complete work in a quiet area. There was a beanbag chair, weighted blanket with a pad, teacher's desk, couple students' desks, a video monitor, a sink, and a storage area. There's an observation window which someone can observe from an adjoining room. The secure observation room were small rooms with padded walls. By the way, my rendition here, don't take that as art endorsing this necessarily. Small rooms with padded walls, lit, each has an air vent and a window. Each is equipped with a video camera. Each is also equipped with a magnetic locking door. On the wall of the door is a button, so someone has to be standing there engaging that magnetic lock through the window. If they step away, it's unlocked. The parents vehemently opposed this. Ultimately, it gets to court. The court first said, there is no evidence to suggest that this was being used as a disciplinary measure or in a punitive fashion, only as a last resort. The data kept on the use of these rooms. November, 29 times. January, 12 times. March, 7 times. April, once. I think the court was impacted by the data to show that, first of all, this was not being used as punishment, but the other interventions were taking effect and having a positive impact. So these ultimate last resort, I'll call them seclusion rooms, the other interventions were effective, so these seclusion rooms were hardly being used by the end of the school year. The court upheld the IEP. And again, it was only used for safety purposes after other strategies were exhausted, based on this evidence. So that was a case. By the way, I want to go back to paragraphs. I want to talk about paragraph 5 on page 8. The highest court that really addressed the appropriateness of a behavioral intervention plan. Here was a case of a child who in first grade was a first grader, regular first grader. Second grade, things started escalating behaviorally. The child was referred and found eligible for special education. Third grade, not a good year. The child was engaged in several incidents, including, among other things, this child was a runner. We're not talking track team. By the way, this third grader was 160 pounds. This child ran off the playground. The playground supervisor pursued him. He picked up a piece of sheet metal and tried to slash her. The school said, "What is going on with this child?" So they conducted a behavioral assessment. Based on the assessment, they added a behavioral component and fully implemented that component. Unfortunately, it was not as successful as they had hoped. He was now starting to assault other students. Remember, first grade was pretty good. His former first grade teacher was now a third grade teacher in the school, not his third grade teacher. But in the middle of the school year, pretty unusual, everyone agreed, including the parent, and his former first grade teacher is now a third grade teacher, said, we got along fine, give him to me. So he switched third grades in the middle of the year. Again, not typical. But sometimes the dynamics between the student and the teacher could escalate situations or not. It didn't take long before he physically attacked his new third grade teacher. She had scratch marks on her breast. She pushed him away with her foot. He had a black and blue mark. The parents filed an abuse report against the teacher. Social services investigated and found no merit to that. In the meantime, the school called in outside behavioral experts to conduct a supplemental behavioral evaluation, and based on their recommendations, they revised the behavior plan and implemented the revised plan. He had a bad hair day and tore a classroom apart where other kids had to be evacuated. The school got out their Sony and kind of recorded what was left. The team meets and determines this is no longer the least restrictive environment for this child and moves the child to a self-contained classroom. The self-contained classroom had 8 students, a full-time teacher, a student teacher, 2 aides, and a social worker. Pretty high ratio. In the meantime, the superintendent writes a memo to staff. Don't put yourself in harm's way. This student attempts to hurt you or other students. You call the police. Now, this happened in northern Illinois. That's where I grew up. It was still the fall, so it was not a good year for this kid, who was still in third grade. The kid, and I find it almost hard to believe with all the staff in this room, the kid bolts out the classroom door, outside the school door. Now, remember, the superintendent said, don't confront the kid, call the police. Well, one of the staff members pursued him, at least to keep visual supervision. What grows tall in the fall in the Midwest? Corn. You may have seen pictures of the maize, Halloween. Well, he ran into the cornfield. The staff member loses him. The police are called. They bring in the police helicopter. Well, you laugh because you were not the parent, the teacher, or the administrator. 2 hours later, they find him stuck in a riverbank up to his hips. His temperature was down to like 95.5. Fortunately, no long-lasting injury. The parent removes the kid from school and files for due process. The former hearing officer in Illinois, key word there being former, held that the behavioral component of that kid was denied FAPE because his IEP behavioral goal had not been achieved. And ordered the school to contract with a private agency to set up a program within the elementary school for him, and ordered disability sensitivity training for the entire school district. It got appealed. Don't write that down. It got appealed. Ultimately, it gets to the 7th Circuit Court of Appeals. The 7th Circuit said, under the IDEA, there's no specific substantive standard that applies to behavioral components as part of the IEP. But just like with every other IEP, an IEP goal is not a guarantee of attainment. What did the district do? Behavior surfaced. The kid had been found on IEP eligible. Behavior surfaced. What did they do? Assess the behavior. What did the team do? Put a behavior component in the IEP. It was fully implemented. It wasn't working. They supplemented the behavioral assessment by bringing in, quote, behavioral experts. Based on those recommendations, the behavioral assessment was refined. The behavioral assessment was implemented. Ultimately, they placed the child in a more restrictive environment. At this point, the school felt that the kid needed a therapeutic day placement. The kid was out of school. The court upheld the school and said, what else can we expect the school to do? In this case, they found no violation of FAPE. And I presented this case some years ago, and it was from Illinois, and unknowns to me, the administrator, special ed administrator for the district was in the audience. She said, you got that down pretty well. And I said, I just read what the court said, and we always know that the courts with 100% accuracy get all the facts and so forth. And I said, I don't want to violate confidentiality, but how is this child doing? And she said, you know, ever since that incident, the parent pulled their child out of school and they've had no contact. I also was wondering, how big is this child by now? But I mean, I want to know, so how is this kid doing? We lost the child. The kid was homeschooled. They saw the kid in the community occasionally, but they would have no communication. Nobody won in that case. But this is the highest court that addressed the appropriateness of a behavior plan. The last case I want to talk about, well, I want to do two things here. If you look at the bottom of page 8, paragraph 6, case from Kansas, where the court said the IDEA doesn't hold schools to the standard of eliminating the interfering behavior, but in good faith you have to address it. But again, you can't guarantee that it's going to be successful and the misbehavior would be eliminated. That is not a standard that we could impose on schools. The last case I'm going to talk about is a case, this is what I call what not to do. Here was a child who is cognitively impaired and emotionally disturbed. How many of you have ever taught in a self-contained class? I'm just curious, how many kids were in your class? 10? 6? 9. Here was a child who was in a self-contained class. And again, this child was not only emotionally disturbed, but also cognitively impaired. And I'm trying to remember the numbers here. I think it was 9 kids. But the teacher, the special ed teacher, had a point system. The point system in the classroom required the student to acquire a certain minimum number of points every day, with each point total differing for different activities, and to achieve those numbers for 8 consecutive days in order to move to the next level where additional privileges were offered. Positive interventions. The student could earn up to 2 points for each of 5 different behaviors. Following directions, staying in your own space, being on task, positive peer interaction, and positive staff interaction. And those 2 points for those particular skills applied during every 7 periods. They were calculated differently for every 7 periods during the day. They were then subtotaled. The student could earn up to 7 points for her 3 personal goals: communication needs, use of sensory items correctly, and completing tasks in a timely manner. She then could obtain 5 points for bus behavior and 4 points for recess. The points are total at the end of the day out of a possible 100. If she made her day on what her IEP required, she had to reach that number for 8 consecutive days to reach the next level of privilege. However, there could also be deductions. She could be deducted. In fact, the teacher deducted her for sleeping even though she had a seizure disorder and took medication, which caused sleepiness. She had several behavioral outbursts where she was physically restrained, but still was rewarded points, while at other times, with fewer behaviors, points were deducted. First of all, the court says, well, and by the way, every child in this class was on the point system. So, teacher, where did you come up with this? PBIS. So I'm thinking, do I have a clicker on my belt? You get, okay, 2 here, deduct. 2 here. The court said this child is not only emotionally disturbed, but cognitively impaired, and I don't understand what you just said. How can you expect that this child understands the expectations that she has to gain the next level of privilege? How do you implement this for all these children in your class? And secondly, for bus behavior, how do you, for every 7 periods, you get 2 here, minus times pi, The court blew it out of the water, and the worst is yet to come. She was repeatedly physically restrained for her behavior, sometimes multiple times, in one case 19 times every day. Not in one day. And there was no indication that it was done for her own safety. She came home with bruises. This is what not to do. By the way, the physical restraint, we didn't even have to get there before the court found FAPE was denied. And the teacher attempted to portray it as a positive intervention system, positive behavioral intervention system. The court said, you fail. Any questions or observations? I hold that up as what not to do. And I don't know as a teacher how I pragmatically would be able to implement. First of all, if I'm collecting these points and deducting and adding and subtotaling, when do I have time for instruction? And maybe I'm just too naive because I've never taught in a self-contained program, but I can't see pragmatically how a teacher could even keep tabs of all of this and provide instruction. I think it's time for a break. Let's take 10 and we'll get back together.